Today, we will discuss about opening of succession and issues that are related to the concept of opening of succession. The central question is, when does succession happen? And what are the implications, what are the consequences, the legal consequences of opening of succession? That's regulated under Articles 826 as the following articles, and we'll see the central issues. We'll try to see the central points that are covered under these provisions, and we will also try to see the judgment which our colleagues were supposed to read. Let's read Article 826 first, and then we'll try to understand what the central issue, the central thrust of that provision is. Article 826, as I said earlier, is about opening of successions. It says, where a person dies, the succession of such person, called the deceased, shall open at the place where he had his principal residence at the time of his death. Where a person dies, the succession of such person called the deceased shall open at the place where he had his principal residence at the time of his death. The first few words of this provision are at the heart of the law of successions. It starts off by saying where a person dies. Succession can only open if somebody dies. If there is no death, the whole chapter, all the sections, all the provisions of the law of successions automatically become relevant. Without death, there is no succession. So the opening of the law of succession, and consequently the relevance of all the provisions in the law of succession, is dependent on the concept of death, on the happening of death. Death is a very relevant event for the law of successions. Without death, there is no law of successions. And the second point is where a person dies. The timing for the opening of the law of succession is related to the timing of death. So succession opens when a person dies. It opens exactly at the time of death of that particular individual, which the law of succession has decided to call a deceased. When an individual dies, he automatically becomes a deceased. And so legal personality there. Starting from the moment of death, human beings are called persons, right? They are called persons because they are depositories of rights and obligations. The moment an individual is born, he acquires rights as well as obligations. There is a possibility of that individual acquiring rights and obligations, and as a result of that concept of rights and obligations, that individual is called a person. Immediately after death, the basic attributes of personality are lost. What are the basic attributes of personality? The basic attributes of personality are the concepts of rights and obligations. And it's also we are going to, legally speaking. Why is a person a person? No persons was the person, legally speaking, an individual is called a person because that individual has rights and obligations. And for physical persons, for human beings, that particular attribute is acquired at the time of birth. And these attributes, which have been acquired on the date of birth, are lost when that individual dies. After death, there is no possibility of that entity having rights and obligations. Therefore, you cannot imagine, legally speaking, we cannot imagine somebody having rights and obligations after the event of death. Therefore, the event, there are two events here. There is an event of birth, and there is an event of death. The event of birth gives rights and obligations, but the event of death destroys those rights and obligations. And after that event, after the event of death, the individual who used to have rights and obligations is called the deceased. That individual is called the deceased. And the whole point of Article 826 and all the subsequent provisions is as to what happens to the rights as well as the obligations that were acquired at during this interval. There is an interval between life and death. That interval can be long or it can be short. But all individuals, all human beings are assumed to have acquired some rights and obligations during this period. Therefore, what the law of succession tries to do is decide on the fate of these rights and obligations that have been acquired during the lifetime of that individual, during the time when that individual was a person. And so the successions. And Article 826 gives us the basic directions. It tells us that the succession opens where a person dies. Succession opens where a person dies. And what the moment that the individual dies, the law calls him or calls that deceased. These are the 2 points. They are very preliminary points, but their points was noted. They are central for our subsequent discussions. Where a person dies, the succession of such person called the deceased shall open at the place where he had his principal residence at the time of his death. When an individual dies, his succession or her succession opens exactly at the moment of the event of death. The moment an individual dies, the succession automatically opens. Therefore, the law of succession automatically becomes relevant. All the subsequent situations, anything that happens after the moment of death automatically becomes the domain of the law of successions because succession has already opened. The moment the succession opens, all the events, all the issues that arise after the event of death usually are the domain of the law of successions. And the other point here is the question of where. I think you have discussed about the concept of residence.
Yeah.
So the residence will do regarding the question of where, the law says succession opens at the time of death. Where does that succession open? It opens at the place of the principal residence of the deceased. An individual may die anywhere. But where does the succession open? The succession opens at the principal residence. I think you remember from your classes of the law of persons that an individual can possibly have a number of residences, right? The law of the Ethiopian and so on. So residence in original. Like a person might have acquired a number of residences during his lifetime or during her lifetime. But the central point where the succession opens is the principal residence. And which of his residences is principal and which one is not so principal is determined based on the law of persons. And you have to try to remember your discussions about those provisions during your classes of the law of persons. The central points for Article 826. 1. Succession always opens when a person dies. Without death, there is no succession. And when does that succession open? It opens at the moment of death. The moment someone dies, the effect of succession. There is no interval between death and opening of succession. And this is so crucial. This is so crucial. If somebody dies at 10 a.m., the succession opens exactly at this time. Therefore, all the rights and obligations of the deceased, all the rights and obligations of that individual, of that deceased, are automatically transferred to his heirs or legalities. Exactly at this point. Therefore, this timing is so important because that's when rights and obligations are transferred from the deceased to the heirs or legalities. ወደ ወራሾቹ መብትና ግዴታ የሚተላለፍበት ሰዓት ስለሆነ this is so central. When the timing of death of an individual is very important in the law of successions, as in many other legal transactions, as in the law of contracts, as in wills, as in many other legal transactions. Time is always important. Time is always important. In the law, the first article of the law of successions tells us that the timing for the opening of succession is the time when an individual dies. Therefore, the concept of death is important for a number of reasons. One, it is important because without death there is no succession. We have to prove that there is death. If somebody cannot prove that an individual has died, then he cannot win any case in the law of succession. And so, we prove the concept, the fact of death, the event of death, is very crucial. Therefore, anyone who claims to have succeeded somebody else must first prove that somebody else is really dead. ሞት ከሌለ ወርስ ስለሌለ የመጀመሪያው ያረጋግጥ የሚጠበቀው ነገር is that individual has died. That's why the first provision of the law of succession starts off by saying when, where a person dies. Without death, there is no succession. Without death, there is no inheritance. Without death, will, the concept of will, when we say, is irrelevant. Therefore, all the legal concepts, all the legal provisions, all those disputes between individuals like the ones we heard about a little earlier become relevant only if there is death. We'll see many more interesting details about these things when we consider the subsequent provisions. But try to remember for the time being that the event of death, however unfriendly, however unattractive it might be in real life, it is very interesting for the law of succession. Without the concept of death, we wouldn't have been. Therefore, this is a very brief about sub-article 1. We'll come back to it when we consider the other articles. We'll come back to it. Let's read Article 2. Okay, when a person dies, succession of that deceased, the deceased is not an individual anymore. It's not a person anymore because that individual has lost his rights and obligations. Death terminates rights and obligations. And if rights and obligations are terminated, then we cannot speak of personality because legal personality is always related to the concept of rights and obligations. Without rights and obligations, there is no legal personality. And if that entity, let's call that deceased D, to make discussions easier, let's call a deceased person D from now on. If somebody has died, what happens to the rights and obligations of that individual? We said Article 1 of our Civil Code says an individual is the subject of rights from the date of birth. Therefore, anyone who has lived, or anyone who has been born, automatically is a beneficiary of that article, and therefore, as a result of that article, acquires rights and obligations. And if death terminates those rights and obligations, what happens to those rights and obligations? What do you think should happen to those rights and obligations? D has enjoyed rights. D has assumed a number of obligations during his or her lifetime. And when that individual dies, when that individual becomes the deceased, and because of that, the intervening fact of death, if that individual loses the legal personality that has been attributed to him or to her during his lifetime, what happens to the rights and obligations? What should happen? What do you think should happen to those rights and obligations? That's why we call him a person. If that entity didn't have rights and obligations, we wouldn't have called him a person. That's why we call individuals persons. They are not so much legally speaking. Biologically speaking, a human being is a human being because of other reasons, right? The biology legal personality. In law, individuals are persons, we are persons, because we have rights and obligations. So what do you think should happen to those rights and obligations? Legal persons have rights and obligations. What happens to those rights and obligations? Which obligations and rights will be terminated? And which ones will be transferred to the heirs? And which ones will be transferred to people who are not heirs? This is what we'll see today. And sub-article 2 gives us the basic direction. Sub-article 2 of Article 826 gives us the basic guideline. The rights and obligations of the deceased, which form the inheritance, shall pass to his heirs. This tells us a very central point in the law of successions in this country, as well as in many legal systems. When we talk about inheritance, we are talking about rights and obligations. So it's not, the heirs are not entitled just to the rights. Anyone who takes the rights takes the obligations as well. So when we speak about succession, when we speak about devolution of succession from the deceased to somebody else, it can be X, it can be Y, it can be descendants, it can be ascendants. We'll see how that devolution takes place. But this devolution involves rights as well as obligations. Rights, no obligations. It's not just rights. Somebody cannot pick the rights but drop the obligations. The whole idea of the transfer is complete. It is the rights as well as the obligations that will be transferred to the next of kin. It can be the descendants, it can be the brothers and sisters, it can be the parents. We'll see how that devolution takes place. We will see how those individuals are picked in the subsequent sections. But remember, for the time being, that the law of inheritance is interested in rights as well as in the obligations. And you can imagine why. The successor, the heir or the legatee, cannot just pick the rights and say, I don't care about the obligations. When a father dies, or when one of the ascendants dies, by the way, anyone in law is assumed to have assets and liabilities. And the law of succession is involved, is interested in streamlining those rights and obligations. It's not interested just in the rights, but in the obligations as well. Why do you think the law of succession is interested in the obligations? Why would the law care about transferring obligations to the heirs? ግዴታዎችን ለምንድን ነው ማስተላለፍ የሚፈልገው? Why? When transferring the rights to the descendants, ህፃናት ከሆኑ አሁን መብታቸውን ሰጥቶ ግዴታቸውን ለማለት ነው። Or if it's the parents who pick, who take the succession, why should the obligations of the deceased be transferred to the parents? You are in effect saying the law says that succession is interested in the deceased, it is interested in the successors, but it is also interested in protecting the rights of creditors or third parties who might have had legal relationships with the deceased. Therefore, we have the laws, the concern, the interest of the law of succession is not just the relationship between the deceased, between the person who died and his successors. በሟቹና በወራሾች መካከል ያለው ነገር ማስተካከል ብቻ አይደለም. There is a social interest. There is a social interest. There is a public interest as well as individual interest of addressing the expectations of surviving creditors. Like the example we mentioned earlier, if somebody has borrowed money from the banks, of course that individual will have assets that he has liabilities. Well, those liabilities which that individual incurred during his lifetime must somehow be addressed. And that can only happen if the law of succession is interested in the obligations as well as the rights. ስለዚህ የውርስ ህግ ዓላማ is not just looking after the interests of the survivors. And so ሲሞት የእሱን ወራሾች ኢንትረስት ብቻ አይደለም. Apart from the interests of the survivors, the law of succession tries to address, tries to protect, tries to streamline the expectations of all individuals who might have had legal relationships with the deceased. If the deceased had acquired rights during his lifetime, of course those rights will be transferred to his successors. But if that individual had imposed obligations on himself voluntarily, or if there are obligations which he assumed for one reason or another, those obligations must be discharged by his successors. But the question then is what type of rights and obligations would be transferred to the heirs, and what type of rights and obligations would be terminated when that individual dies. ምን አይነት መብትና ግዴታ ነው የሚተላለፉ? ምን አይነት መብትና ግዴታ ነው ከሟቹ ጋር አብረው የሚሞቱ? ጥያቄ ግን is a central question. The law of succession is interested. The law of succession kind of makes we can say, if somebody dies, you can divide rights obligations into two. There are rights and obligations which get terminated at the time of death. And there are rights and obligations which get transferred on the date of death. The law of succession is not interested in this category of rights and obligations. The law of successions, there are some rights and obligations which can never be transferred to somebody else. ባልና ሚስት ከነበሩ the status of being a husband cannot be transferred. If somebody is a brother of another person, that brotherhood ወንድምነት ነገር ሊተላለፍ አይችልም. It is acquired, it is a right which that individual acquires as a result of the law of marriage, but it cannot be transferred. If somebody has a right to elect or to be elected, it is a constitutional right, but it cannot be transferred. There are so many rights of this type. There are so many rights which can, because of their very nature, cannot be transferred to other individuals. And so, ሲሞት ይዞት የሚሞት ማዕት መብትና ማዕት ግዴታ ይኖራል. The law of succession is not interested in this category of rights because those rights and obligations will definitely terminate on the date of death. The opening of succession does not give life to these rights and obligations. እነዚህ መብቶችና ግዴታዎች ሰውየው ሲሞት አብሮ ስለሚሞት there is no point that can be covered. There is nothing left that will be regulated by the law of succession. Both ህግ የሚዳኝ both ህግ የሚታይ therefore when we talk about the law of succession, we will not be talking about these types of rights. Therefore, you have to be very careful when you handle cases of law of succession. You have to classify rights first. The first thing you have to try to do always when you deal with succession issues is try to categorize rights. Make a balance sheet of rights and obligations, and try to make a distinction between rights that are terminated on the date of death and rights that are terminated on the date of death. Those rights and obligations will not form part of succession. The law of succession is interested on rights that are transferred. And rights that are transferred form part of inheritance. The rights as well as the obligations which are transferred to the heirs are called they form ምን ይባላል? Inheritance. This is a legal concept which we will be dealing with. Inheritance የሚለውን ፓኬጅ ነው። Unpack ለማድረግ እንሞክር. That's what we try to do. We try to unpack the concept of inheritance. Rights and obligations are therefore within the category of inheritance, and we try to answer who takes that inheritance, what that inheritance consists of, and many other related issues. Man ነው ያን inheritance የሚያስተላልፈው፣ እንዴት ነው የሚተላለፈው፣ መቼ ነው የሚተላለፈው, and all those things will be the issues we will be discussing during this semester. But remember, we are interested in inheritance and nothing else. Nothing else. በinheritance ውስጥ የማይገባ rights and obligations. There will be rights and obligations that do not fall within the category of inheritance. If they don't fall within the category of inheritance, we will not be interested in them. Not that they are not that important, but they don't fall within the ambit of the law of succession. The law of succession is interested only in inheritance. Inheritance means right and obligations, but the right of obligations that are not terminated at the time of death. Therefore, I think for purpose of convenience, we can classify rights and obligations into three broad categories. We can classify rights and obligations into three broad categories. The first category would be rights and obligations that get terminated, that die together with the person. Personality ጋር በጣም የተያያዙ they are so much related with the concept of legal personality, they cannot survive that concept. Therefore, when that concept of legal personality becomes to an end, so do the rights, so do the obligations. They cannot live without the owner of those rights. They are so personal, they can never be transferred to somebody else. This category of rights and obligations, we can consider them as one package. That category of rights and obligations, this falls under this category. The second category of rights are rights and obligations that are transferred to the heirs. There are rights and obligations that can be transferred, and there are rights and obligations that are transferred to the heirs and legacies. ለወራሾቹ የሚተላለፍ መብትና ግዴታ. We'll see that more shortly. This is the second category, and the third category is a category of rights and obligations, but those rights and obligations will not be transferred to the heirs, but to somebody else. Can be, for example, the wife, or it can be the husband. I'm not trying to look gender insensitive. When we take examples, we have to be very careful that under Ethiopian law, spouses are not successors. So let's say the third category consists of rights and obligations. Those rights and obligations can be transferred, but they are not transferred to the heirs. They are not transferred to the legatees. They are transferred to somebody else. ወራሽ ያልሆነ ሰው የሚተላለፍ መብት አለ. If you had read the judgment, you would have seen this category. In case የኛውን ይበልጥ ዛሬ እናየዋለን. It's very clear about this categorization of rights and obligations into three broad categories. We have rights and obligations that terminate on the date of death, not the date, at the time of death. We have rights and obligations that survive the deceased, meaning that carry on, that are carried over to the heirs, to the legatees. And we have a third category of rights and obligations that are carried over, but not to the legatees. They don't form part of the inheritance. They don't form part of the inheritance because they are transferred to somebody else. Therefore, they are covered under different other laws. They are covered, they are discussed, they are considered in different branches of law. ለምሳሌ አንድ ሰራተኛ ሲሞት if an employee dies, that employee, the relatives of that employee will be entitled to some compensation. That compensation is covered by labor law. If somebody dies in a car accident, of course the relatives will be entitled to some compensation. Those compensations will be covered by the law of torts. If a pensioned individual dies, relatives, the surviving relatives will be entitled to some amount of payment. But that payment is governed by the law of pension, not the law of successions. So let's see, inheritance, the law of successions is interested in inheritance. Inheritance means rights and obligations that are transferred to the heirs and legals. Anything that's rights, some rights and obligations can be transferred, but that they might have been transferred to not the heirs, but to somebody. If a husband dies, for example, we will usually kill husbands during this session. I hope many of you will agree. If a husband dies, the wife is not an heir. Under Ethiopian law, wives are not heirs. Neither are husbands. If the wife dies, the husband cannot succeed his wife. Therefore, spouses under Ethiopian law do not succeed each other. But that doesn't mean they are not entitled to any kind of payment. But that payment does not fall under inheritance. ስለዚህ በሎ ሰክሴሽን እና ኢንሄሪታንስ የሚለው ኮንሰፕት ብቻ ከዛ ውጭ ያለ የንብረት መተላለፍ በሌሎች ህጎች የሚዳኝ ነገር ነው። We'll perhaps see one of the cases that we show you clearly. Let's see some other aspects of subartitude. The rights and obligations of the deceased which form the inheritance shall pass to the heirs and legates. Rights and obligations which form the inheritance. The rights and obligations which form the inheritance. Rights and obligations which do not form part of the inheritance are not the subject matter of the law of successions. But anything that forms part of the inheritance is transferred or passes to heirs and legates. What do you think is the distinction between heirs and legates? Who is an heir and who is a legatee? From what the two of you said, an heir is a successor who acquires rights and obligations by operation of law. Is it? Who succeeds the individual because of the will of that man. Is that what you wanted to say? To the law of succession, that's why I wanted you to think about it. Rights and obligations that form inheritance are transferred to either of two categories. ንብረት ይተላለፋል። ንብረት የሚተላለፈው ለማን ነው? Property passes either to an heir or to a legate. ወይ ለሄር ነው የሚተላለፈው ወይ ለሊጋት። Who is an heir? An heir is someone who succeeds by operation of law. Who picks the heirs? The law picks the heirs. Who picks the legatees? The legatee is picked by the deceased. If the deceased makes a will, አንድ ሰው ከመሞቱ በፊት አስተዋይ ከሆነ እና ከተናዘዘ, then we have a legate. If the individual doesn't make a will, then what do we have? We have heirs. Try to remember this distinction. I'm sure you will get used to these words, to these concepts as we go further, as we go deeper into the law of successions. But for the time being, try to remember that there are two categories of potential successors. There are two possible potential successors. The first potential successors are the heirs. The other potential successors are the legatees. And the question which is central in all legal systems is on which one comes first. Which one do you think should come first? If X decides, we have legals. If the law decides, what do we have? We have heirs. ከነዚህ ሁለቱ ማንኛው ይቀድማል? በምን አይነት ሁኔታዎች የሚለው of course will be the center of our discussion during the law of successions. And we'll briefly see in the next the basic direction as one እናየዋለን. Remember, it suffices to note for purpose of Article 826 that any property that forms inheritance, part of the inheritance, is transferred either to legatees or to the heirs. When legatees ነው የሚሰጠው ወይ ለheirs ነው የሚሰጠው. If somebody is not a legatee, if somebody is not an heir, if he doesn't or she doesn't fall in either of these two categories, then he's not or she is not entitled to get anything on the basis of the law of succession. ስለዚህ በውርስ ህግ አሁን ከዚህ በኋላ በምንወያይበት ህግ ማን መሆን ጠቃሚ ነው? ማን ሆኖ መገኘት ጠቃሚ ነው? ወይ ኤር ወይ ሊጋቲ ሆኖ መገኘት ጠቃሚ ነገር ነው። One has to prove መጀመሪያ ምን አለ? Somebody must prove that there is death. What else is that individual supposed to prove? That individual is supposed to prove that he is either an heir or a legatee. Therefore, that an individual, we must, there are a number of interrelated concepts here. We must have death, we must have inheritance, we must have legatee or an heir. That's what we are going to see in the forthcoming sessions and the forthcoming provisions. Let's see Article 826 a little further. What have we seen so far? Sub-Article 2 rights and obligations of the deceased which form the inheritance. Only those rights and obligations which form the inheritance are interesting for the law of successions. Anything that does not fall within the concept of inheritance is irrelevant. Inheritance ያልሆነ ነገር the law of successions to be inheritance የሆነ ነገር ብቻ እዚህ consider እናደርገው. Therefore, you have to always ask yourself, does this fall under inheritance, under the category, under the package of inheritance, or is it something else? If it is something else, of course, it's not interesting for the law of successions. Also, I believe is very important. And of course, that inheritance will be transferred to either to heirs or to legatees. Heirs are successors determined by law. Legatees are successors determined by the deceased. It's not, they are not determined by law, but they are determined by the deceased during his lifetime. Therefore, in principle, individuals are allowed to pick their own successors. Individuals are allowed to pick as to whom to give their property during their lifetime. Law of property, I Law of property, owner on, well, to be an owner, ownership is on. You know, the concept of ownership gives three fundamental powers to the owner. Ownership power, it gives three powers. It gives the right of users, properties, and abusers. And the third power, one of the three powers of ownership is the right to dispose of your property. አንድ ሰው አሁን ሞባይል ካለው ሞባይሉን መስዋዕት ይችላል። ሞባይሉን መስዋዕት ይችላል። ጫማ ያለው ሰው አንድ ጫማ መጣል ይችላል። አንድ ጫማ መች legally speaking, I don't think anyone will be that stupid, but the right to be stupid, yeah. The law of successions is an extension of law of property. የንብረት መብት አንዳንድ ቅጥያዎች ስላሉት ነው ይሄን ጥያቄ የምናነሳው። to what extent አንድ ሰው በህይወት እያለ ማስተላለፍ የሚችለውን ነገር ከሞተ በኋላ ምን ያህል ነው In any case, generally speaking, let's speak generally for the time being. We'll see the details when we cross the bridge. But generally speaking, an individual is allowed to pick his own successors. If that individual fails to pick his own successors, the law picks successors for him. Only for the family. Details, exceptions, we'll see them afterwards. But in principle, successors are chosen by the deceased, because we are talking about rights and obligations of the deceased that are acquired during his lifetime. It is for him to pick, or it is for him, for her, to pick her own rights, her own successors. But if that individual fails to pick successors during his lifetime or her lifetime, then of course the law will pick one, and we'll see how that is done by the law. Well, the last part of Article 826, we already discussed it. Rights and obligations form part of the inheritance unless such rights and obligations terminate by the death of the deceased. If rights and obligations terminate by the death of the deceased, of course, those rights and obligations do not form part of the inheritance because they are already terminated. Therefore, the law of inheritance, the law of succession, is interested in rights and obligations, but only those rights and obligations that survive an individual, that survive legal personality. ከሊጋል ፐርሰናሊቲ ባሻገር ከመጡም በኋላ በሚቀጥሉ መብቶችና ግዴታዎች ላይ ብቻ የላው ኦፍ ሰክሴሽን ሲሆን Therefore, what we can gather from Article 826 is an introductory provision, but it tells us so much about the law of succession. It tells us that succession happens on the date of death. It tells us that death is to begin with an important event for the opening of successions. It tells us that when death, the event of death happens, the succession of that individual opens on at the place of his principal residence, and the choice of residences, picking one residence as a principal residence, will be dependent on the provisions of the law of persons. And of course, our Article 2 also makes a very broad distinction between rights and obligations that terminate and rights and obligations that are transferred to the successors. It also tells us broadly again that rights and obligations which do not terminate on the date of death are transferred either to legatees or to heirs. And the choice, of course, depends on the deceased. This is a very introductory statement, a very introductory provision, and all the subsequent provisions we will be discussing about 300 articles, and all those 300 articles and sub-articles are interested in resolving the basic issues around Article 826. በጣም ዲቴይል ብዙ ነገር አለ፣ ግን ሴንትራል ሀሳቡ እዚያው ያየ ነው።